Respected viewers, I am going to discuss a very important case recently decided by the Honorable Supreme Court of India on the issue of Uniform Civil Code. Article 44 of the Constitution says that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. The government of Uttarakhand recently appointed a committee which is headed by the retired Judge Ranjana Prakash Desai, and the other members of the committee are retired Judge Pramod Kohli, social worker Manu Gaur, retired IAS officer Shatrughan Singh, and Vice Chancellor of Doon University Surekha Agrawal. The task of the committee is to prepare draft laws or suggest changes in the existing laws on several subjects, which include marriage, divorce, property rights, succession, inheritance, adoption, maintenance, custody, and guardianship. The committee has sought suggestions and recommendations from the public and residents of the state of Uttarakhand. The petitioner Anup Barnawal filed a writ petition civil number 1086 of 2022 in the Honorable Supreme Court of India, challenging the constitution of the Committee on the Uniform Civil Code set up by the state of Uttarakhand. According to the petitioners, in view of the directive principles of state policy, which is mentioned in Article 44 of the Constitution, such a committee can only be set up by the union government and not by the state government. The matter came up before the bench of Honorable Chief Justice of India, Justice D.Y. Chanchud, and Honorable Justice Narasimha on 9th of January. After hearing the parties, the court passed order referring Article 162 of the Constitution, which says that subject to the provisions of this Constitution, the executive power of a state shall extend to the matters with the respect to which the legislature of the state has power to make laws, provided that in any matter with respect to which the legislature of a state and parliament has power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by the Constitution or by any law made by the Parliament upon the Union or authorities thereof, Council of Ministers. Further, the Honorable Court referred entry 5 of the concurrent list of the Constitution, which says that marriage and divorce, infants and minors, adoptions, wills, intestacy and succession, joint family and partition, all matters in respect of which parties in judicial proceedings were immediately before the commencement of this Constitution subject to their personal law. Therefore, the court held that in view of Article 162 of the Constitution, which indicates that the executive power of a state extends to matters with respect to which the legislature of the state has power to make laws, and in view of the provisions of entry 5 of the concurrent list of the 7th schedule, the constitution of a committee cannot be challenged as ultra virus. And the Honorable Supreme Court dismissed the writ petition. Thank you very much.